Yes, Mr. Keith.
My Lord, I concluded my submissions before lunch, unless the court has any further questions.
Not from me, thank you. No, thank you very much. Yes, Mr. Georges.
Thank you, my Lord. I just wanted to address the court on the issue that my Lord Dingemans proposed in respect of the relationship between the standards of proof in asylum cases and humanitarian protection cases.
Yeah.
Now, I apologise, I haven't had the opportunity to provide any written support, documentary support for my proposition, but I understand that this is agreed now. The origins, of course, of the humanitarian protection grant of leave or ground of appeal is the 2004 directive, qualification directive.
Yeah.
Namely 2004/83/EC, and in that directive is the test at Article 2E, which is a familiar test, whether there are substantial grounds shown for believing that the person concerned, if returned to his or her country of origin, would face a real risk of suffering serious harm as defined in Article 15. And that test is the same, or was the same, in the immigration rules at the relevant times, that is, up until the changes tentatively alluded to before, which don't apply, which came into force from 28th of June 2022. Until that date, paragraph 339C of the immigration rules mirrored the test I've just referred to in Article 2, the qualification directive. And if the court would like, I'm more than happy to go away and produce, maybe together with my learned friend, a short agreed note.
I think that would be helpful if the two of you could. Thank you very much indeed.
Grateful. The reason I mention this real risk is because that terminology is also used in the authorities which are before the court.
Yeah.
Particularly MAH, Egypt, relying on the case of Ravi Chandran, which was the decision or judgment of Lord Justice Simon Brown, where he approves that formulation, which is actually taken from the ex parte Sivakumaran case for the House of Lords. All of those cases obviously predate the introduction of the directive, and so are not strictly on point, but we say that the same terminology is used, and therefore that is why, in practice, the same standard of proof is applied, and that is borne out by the Secretary of State's approach, both in the rules and in the guidance that she provides to her decision makers. In essence, the same credibility assessment is to be conducted, and the difference is in general cases where the reason for the fear is not a convention reason, and so commonly the tribunals will consider the factual elements of the claim without looking into the ground, and then if it's found that the claim does not engage the Refugee Convention because it's not on one of the specified grounds, then in essence the court will move on to humanitarian protection. And indeed, if a person who finds himself excluded from either or both, then the test is carried over through to the Article 3 ECHR assessment. So I hope that, as I said, I'm more than happy to work together.
Thank you. Would you be able to think to do that by close of play on Friday?
Certainly, I can do that for my part.
That would be very kind.
Yeah, thank you very much indeed.
My reply is going to be short, obviously.
Yes.
My learning submissions were short. I just wanted to address the court briefly on three matters. First, I want to deal with the martyr certificate. There was a suggestion that the First-tier Tribunal had failed to consider the provenance of the document. Respectfully, I would submit that that was not really the issue before this tribunal, because the Secretary of State didn't challenge its reliability, and indeed it was consistent with her case, which was that's going to get you an exemption.
Well, the Secretary of State relies on its truthfulness.
And I observe, and I already have, that both parties, in fact, relied on it, were agreed on what it meant. Namely that it would entitle him in law, in Vietnamese law, to an exemption from service. The other aspect of this martyr certificate is the point addressed to me by the court, which was the failure of the first-tier judge to address that certificate in terms at paragraph 44. My response to that has already been made. In effect, we have to look at all of the reasoning together, and that the judge had already addressed the martyr certificate in the context of assessing the plausibility of what the appellant had said had happened. And because we're focused on the account of past events, that was sufficient. It was not an error for the judge not to mention it again at paragraph 44. And my response would be, if it is a matter of one sentence, that in 44, if the first-tier judge had said, I take into account the martyr certificate, but for the reasons I've given, I nevertheless find the account given to me reasonably plausible. If that sentence was in 44, then presumably that would be enough to answer that complaint. But I submit that the fact that it's not does not mean the judge has erred, because it has to be read together with the preceding passages, where she did engage with it. The second set of the area I wanted to address, if I may, was to do with this idea of the serious concerns, and my learned friend was asked what the serious concerns were. Paragraphs 37 and 38, which are the first two paragraphs following the heading, factors that damage the appellant's credibility. The judge refers at 36 to the well-established authority of TK Burundi, where, in essence, the principle is that where evidence is reasonably available, it is a matter which can be taken against the credibility of an appellant, even though there is no general requirement for an appellant in a protection case to corroborate their account. For that reason, 37 and 38, the judge takes two failures to produce evidence which was reasonably available as matters that cause her concern or damage the appellant's credibility. As we see, paragraph 37, although the judge accepts the explanation in respect of the 2010 recruitment order itself, the judge doesn't consider it, takes it against the appellant that he's failed to produce the evidence that he says he attempted to obtain it. The judge says, well, that there should have been emails and letters that you've written to try and get it since you've been here to support your case, and took that failure against this appellant. And equally, paragraph 38, the judge finds that he could have obtained evidence from family members in Vietnam to support his case. That would have been reasonably available to him, and that his failure to provide those statements is damaging to his credibility. So those are the two concerns, both the failure to produce relevant or reasonably available evidence. And then, of course, there's the delay, which the judge considers at this point, because it is a factor which damages the appellant's credibility, albeit the First-tier Tribunal goes on to conclude that she's prepared to attach relatively little weight to that particular factor. And as I've already submitted, probably more than once, that is a substantive assessment that was challenged, but the challenge was not made out. The suggestion that it's impermissible for this court to read out the word serious, I deal with in two ways. First, even if they did represent serious concerns, as the judge expresses, then that is still not enough to make out an error of reasoning, because she also finds that this is a consistent account and not an implausible one. And that, applying the lowest standard of proof, is capable of outweighing, to use the dangerous and probably wrong terminology. But moreover, if this is a reasoning challenge, then one only has to look back at the preceding paragraphs to actually see what the judge had to say about those concerns. And therefore it is permissible for this court to read the decision fairly and as a whole, and ultimately conclude that they were not particularly serious, and certainly in the end they were not sufficiently serious to persuade the First-tier Tribunal that the lower standard had been met in this case. I also stop finally on this point to say, ignoring all the other errors that were pleaded and were found, if this was the only error in the First-tier Tribunal's decision, my submission is that it would be insufficient to set aside an otherwise clear, coherent, and considered assessment of credibility. It is a prime example of cherry-picking a particular paragraph forensically. And the task of this court, or an appellate court, is to read the decision fairly and as a whole. The final point is essentially to deal with the admission by my learned friend that the First-tier judge didn't tackle the issue of sufficiency of protection. My simple answer to that is the judge recorded the position, was agreed. There was no dispute that there is in general a sufficiency of protection. So that explains why the judge did not go into consider in detail the issue of sufficiency of protection. At paragraph 27 of her decision, the judge records the facts which weren't disputed, one of which was someone who's a children of a martyr is exempt from conscription. And then at 32, the judge agrees with the Secretary of State's presenting officer's submission that in general due process exists. So the judge had well in mind the issue of sufficiency of protection, and as I've repeatedly said, its relevance in this particular appeal is to the assessment of the plausibility of what she had heard. I conclude by saying this is a reasoning challenge. So the court must ask itself, is it able to understand why the First-tier judge accepted the opponent as credible in his account of past events? And in particular, are we able to understand why she was satisfied that he had not made greater efforts than he did to seek protection? The question is not whether we might reach a different conclusion, but whether we can understand the reasons why the First-tier accepted that. I say that it is reasonably clear. In essence, he didn't think that the police in his home area would help him for the reasons we covered. And after he tried to complain, he was subjected to further ill treatment. That simply needs to be an intelligible reason, not a persuasive one. It's not suggested that it's perverse. So I submit that this reasoning challenge, in essence, is not made out. Unless
Just on paragraph 44, the sort of fifth line, where, which I think you've just been sort of looking at with the reasoning, the judge there says, having considered all the evidence in the round, I find to the lower standard of proof that these factors outweigh the factors that count against the appellant's credibility. That was one of the criticisms of the Upper Tribunal. It is what you're saying, the proper construction of that the first-tier tribunal judge is saying that the findings of plausibility are sufficient to outweigh the serious concerns, if they were serious, above.
That is the way I read this paragraph. I don't think it's helpful that the judge has used the word outweigh. If the judge had simply said, notwithstanding the concerns or serious concerns I have, nevertheless, I still find that the lower standard of proof is met, then I'm not persuaded that we would be arguing about this.
No, that's certainly true.
But I think I can submit that that is ultimately what this judge is saying, and that reading this fairly as a whole, this court can accept that.
So that outweigh, read fairly should mean, sorry, just so that I've got it.
Rather than that these factors outweigh the factors that count against, it should be read that either notwithstanding the factors that count against or despite the factors that count against, I nevertheless find the lower standard of proof is met and the appellant is credible. So there may well be some infelicity of phraseology in paragraph 44, which has understandably been jumped upon by the first-tier judge who granted permission and the Upper Tribunal judge. But I submit that that is not a solid foundation to find an error of law when we read the rest.
Thank you.
Thank you very much. Mr. Georget, Mr. Keith, thank you both very much indeed. We're going to reserve our judgments. In the usual way, we'll circulate drafts for you to assist us by correcting errors and the like. The drafts will obviously be on the usual terms as to confidentiality, and then we will be aiming to hand down judgment remotely. So when you have the drafts, if you could please try to agree on an order and any consequential matters. If there is any insoluble disagreement between you, then perhaps you could just make brief written submissions and we will aim, if we can, to resolve them on paper without a further hearing. Thank you both for your submissions today, on which we will now reflect.